All right. Good evening, everyone. Thank you for joining us. Welcome to HBAP Startups. Tom is waving. I love it. Thank you very much. Let me click on the next slide. So for those of you who are new to our group, we have a few announcements that we do at the beginning of each meeting. We do some short networking breakout rooms, and then we'll come back together for our main event. And first off is our mission. And we are here to help foster an innovation and entrepreneur community coming out of the Harvard Business Analytics program. And our goal is to provide our members with the tools, knowledge, leadership, and confidence necessary to create and grow their businesses from the ground up. We have, for those of you who are HBAPers, we post on our internal Slack. If you want to, and if you're not an HBAPer, you can apply, and there's a chance that you'll get in. For those of you, okay. We do have a startups newsletter. So I'm going to put this into the Zoom chat. Please sign up for this, and we can newsletter you. And also, we're trying to expand our community, so please feel free to bring a guest and let them join. Susan.
Yes. So in the spirit of that mission that Todd just went over, we want to create an inclusive environment, a place where we can all come and talk about our ideas, or float some thoughts out, or even give feedback to each other. And so just a couple of reminders that in the spirit of confidentiality and collaboration, all rights are reserved by the presenter. In this case, David is willing to share his materials with us, which I think is going to be wonderful. And then, of course, HBAP's honor code, ethical behavior, and then Francis Fry's feedback approach, as always. So every piece of startling feedback, we want to give 5 pieces of warm, optimistic, and uplifting feedback. And then, as always, if you're concerned about anything, conflict of interest, confidentiality, whatever it is, just reach out to Todd and me, and we'll figure it out with you.
Awesome. Thanks, Susan. I don't see any new folks, so I'm going to skip over the new faces. Upcoming. Well, tonight we've got David Rickerby. Next week, we've got Miko Yuk. She's going to be talking about from the enterprise to a startup. That's going to be a very fun presentation. November 2nd is our social overtime. November 9th, our very own Victor Capo is going to be talking about design thinking. November 16th, Dr. Stan Pankratz is cultivating affordable algae for food. Then we're going to be on break for Thanksgiving. November 30th, we are preparing, Susan, Victor, and I are preparing a differentiated value proposition workshop. We met earlier today, and I'm very excited about this. Again, another social. And then on December 14th, very special guest, Mary Spender, who is a famous YouTube musician. She's got over 6 million followers and subscribers on YouTube, a guitarist, vocalist. She's going to be coming and joining us to talk about the 21st century musician. That is please do not miss that. That should be a lot of fun.
Then on December 21st, unless we get some kind of like out of this world intergalactic speaker, we're going to have a holiday social where we expect and request that people wear whatever weird Christmas or Hanukkah or any other celebratory attire that you have, and we'll just hang out together and celebrate another year and going into another holiday, and that'll be fun with everybody.
All right, so let's do some quick breakout rooms. I think I got them working. I will see you guys in about 5 or 6 minutes. I'm going to pause the recording. I'm going to start the recording. Welcome back, everyone. I hope you enjoyed your breakout rooms. Real quick, just a reminder, we will do a little poll at the end. Please stick around for some overtime. And without further ado, it is my honor and pleasure to introduce David Rickerby. to everyone. David has specialized in complex technology and business relationships for more than 20 years. He's worked in-house in the venture capital and intellectual property groups of prominent law firms as an equity partner, managing the technology transaction practice of one of Boston's top firms, and is the founding partner of Boston Technology Law. BTL is a boutique law firm that provides general counsel and technology transaction type services for companies that range from tiny startups to publicly traded household brand names. BTL has expertise in corporate formation, early stage financing, intellectual property, data privacy, technology licensing, and commercial transactions, among several other areas. David has been named the Legal 500 for technology transactions. He has been listed as a Massachusetts super lawyer and a Massachusetts Super Lawyers Rising Star for many years, including 2021 and 2022, which means the law industry did not collapse during COVID. So now, without further ado, if we could all please briefly unmute ourselves, and let's give a warm round of applause to David Rickerby. David, thank you for joining us. Let me stop sharing. The floor is yours, and I think you are still on mute. Yeah, who's going to sign language?
Yeah,
right, there we go.
I am unmuted, so fabulous. Let me see one thing here. I'm going to post here, I think, if Control V works. I just posted in the chat the link to the presentation I'm going to have on the screen. That's presuming that Box hasn't somehow got a security lock on it, but anybody who's got Box should be able to get it. I'm also happy to provide this directly to anybody who wants it. And I'm going to throw up the presentation on the screen so that you are not distracted by my ravaging good looks. And we will take it from there. Share screen 2. As I said, this is a new presentation for me, so I am going to work through it. I understand you want me to talk for about 20 minutes, correct?
You can talk for like an hour or two if you want. We'll be here. So I mean, 20, 30 minutes, open it up for Q&A, but it's
Okay. So I had 2 hours. Never tell a lawyer he can talk for 2 hours.
you can counselor, you can speak for 2 hours. We're here.
Never tell a lawyer that. So what I did, so what this is an apple a day won't keep the lawyer away. 10 steps to take now to avoid legal headaches later. I understand that not everybody here is a straight up startup, but these are the things that I've seen over my career that come back to make my clients miserable. And the things where, they're like, I wish that I'd had an hour with you, 5 years ago to tell me these things. So this is you guys getting that hour. There really is more than an hour of stuff to cover here, which is one of the reasons that I wanted to make the presentation available, because it's got sort of the bullet point list on it. And when we get to Q&A, if there are items that anybody wants to particularly ask about, because I sort of breezed past it, feel free. But these are the sort of the main headache items I see. So I'm going to start with the number one item is get your relationship with your co-founders clear and in writing. This is, when it goes wrong, one of the most painful items, because people's sort of emotional expectations change from day to day in a startup. And, you have on Tuesday, I'm done with this, I'm going to go. And on Friday, they think that they are the most valuable person the startup has ever seen, and it couldn't possibly have existed without them. And so you just want to deal with the tough issues at the start, and just to have a clear expectation when everything's worth nothing and everything's still on the table as to what you're going to do. The first thing I would say is you want to make sure you've got an alignment on goal and vision for the company. That's, you know, you want to have a good personality fit, obviously, but you want to know where it's going. And we'll get very quickly in number 2 to, you know, you want to be thinking about the same exit. Because when I've got 2 founders who have a different view in terms of how hard they're going to work, how long they're going to work, how long they're going to go without pay, you know, that sort of is a disaster waiting to happen. The next several of these provisions are really just sort of the things that you're going to tick through. And, you know, we'll talk about the equity split, but you want to have the equity split understood at the start. You want to make it pretty clear that the company can always buy back the stock if a founder takes off. That's a mistake that I have seen unfold. And when somebody's gotten founder shares, and then my Dick Testa, the founder of the law firm that I sort of learned all this at, used to say, you know, it's not like they're just going to freak out. It's like this is back when the White House was held in high regard. He'd say, what if your co-founder gets a White House fellowship? You're going to want them to leave and go to the White House. So you want to know what happens to their shares if that's the case. But similarly, what happens if your co-founder makes a deal and gets hired by one of your competitors? You know, you want to get that equity out of their hands. Vesting, we'll talk in more detail about later, but you want vesting established early and with the co-founders. I will say that it's a lot of co-founders say, well, why do I want vesting? You know, this is our company now. Why can't we just each have, I'm getting 50%, she's getting 50%. And it's because you want that stock to vest over time to, you know, so that if one of you does leave early, if one of you doesn't sort of show the full commitment, the shares are there for the company to claw back. And also, if you negotiate the vesting between yourselves now and have your friendly lawyer draft it, then there's a chance, not a great chance, but a chance that when the venture capitalists come in and say, we're going to dictate vesting terms to you, you can say, but we've already got vesting terms and we've already agreed on this. And so it gives you this sort of the chance to have a anchor dropped as to the vesting terms. You do, one of the things that sort of like goal envisions is time commitments. I frequently see, you know, especially when it's early stage and there's not a lot of money, and one of the founders has got loans to pay, a family to support, a really bad gambling habit, whatever it is, they need to know how much time that they're dedicating to the startup. And the answer, by the way, if you're going to be a venture capital backed startup, is all of it, right? It is, you know, you're not getting fundraising capital with founders who are part-time founders. And that's really can be a really hard issue, especially when you've got startups coming out of academic environments where you may have a founder who's a professor or, you know, and needs to take a sabbatical to actually get the thing up off its feet for a year. There are as many ways that sort of I've seen the time commitment thing play out as there are, you know, sort of faces of people. It's very different, but it's something that you want to have clear. Salaries, you're usually not going to get paid a lot. It is important always to remember that if you are actually have an employee of the company, they need to get paid minimum wage. If you are just the owner of the company and you don't, you know, you are not an employee of the company, you do not need to get paid minimum wage. But that is a common and stupid mistake where people will make themselves an employee of the company, you know, or take on someone who's like, well, he's going to be a co-founder, but he's a company employee, and you know, and then we'll have a wage setup that is nothing like, you know, won't meet minimum wage, which nobody's going to complain about until you have a nasty separation, and then the person comes back and says you were breaking minimum wage laws, and there's all sorts of nasty repercussions from that. Obviously, you want to figure out you're going to make major decisions. That'll be one of the first things that you get asked when you set up a corporation. But you want to figure that out. Bad actor removal is one I learned the hard way after one of the founders of one of my corporations got put on the Syrian do not contact. I'm forgetting the government acronym, but basically got declared a terrorist by the Trump administration because he was Syrian. And then we had to figure out how to get his equity back, although placing a phone call to him from any of us, this was done while he was out of the country, would have been a felony. And you can understand that. And then you try and raise funding in a company where there's a percentage of the shares held by someone that nobody can actually call. So you want to think about, what happens, and that's, if you're removed as a bad actor because you have a gambling problem or do something terrible, but also if you just by circumstances, by trade regulation, get locked out. You do want to think about the contributions that people are making, and that again will come up early on in your formation of the company, and that really is a tax question. And then the three big things, the three things that deserve all capital letters, and one of them I will have in all capital letters several times, is you want to get an assignment of IP rights. You want that done on day one. You are both contributing to something. This is one of the reasons you need to start a company right away, because you need to have a body that it is possible to put the IP in. Because what happens is if you don't have the IP sitting in that body and then you reach a difference of opinion at some later day, though the specter of an IP case can be, $100,000, $200,000 or more in legal fees just to start getting it sorted out. And that's a killer for a startup. And it gives the founder who didn't sign the assignment of IP rights disproportionate leverage. You want a non-disclosure for the same reason, and you want to work out if there is a non-compete among you when you have multiple founders, because again, it's okay, you got a White House fellowship, that's fine. Then the White House fellowship ends and you come back to work and you create a competitive startup, that's a problem. So all of those are things that you want to think about. And I'm not going to go through all of these bullet points in the same detail as that one, but these first three bullets are really where I see the big expensive mistakes. And that one, number one, is where the real heartache is, because that's where you have two people who were friends who had a shared vision at some point, and then they disagree and they start to break apart. And because they don't have these things worked out, it just gets really, can get really unpleasant. So it is important to be aware of those. The second item, so you've decided you want to have a startup, you've got your arrangement with your founder, your co-founders, at least somewhat clear in writing, is to choose your corporate form. Although I say that here as plan for your exit when you incorporate. Because the second big mistake I see is people will show up and be like, yeah, I met him when I was in Chicago, so we have an Illinois LLC. And an Illinois LLC is a great thing to have if you want to, have your tax losses show up on your tax return and are going to be earning income and want to have a lifestyle company. But if you are seeking venture capital funding, it is completely worthless because you are not going to get venture capital funding in an Illinois LLC. So you want to, at the beginning, I sort of give this talk to some of my founders where I say, you want to think about, am I raising venture capital? Am I raising angel capital, which these days is pretty much the same, but might be slightly different? Or am I just creating a lifestyle company where I want it to throw off revenue or royalties or something and support me, but I'm not ever thinking that I'm going to have some big capital gain at the end? If you are creating a lifestyle company, or if you have certain angels who want to realize tax losses, because there are angel investors out there who want those tax losses, then you're going to, if you go with a corporate form, you're going to be an S corp, or you're going to be an LLC, most likely. And I'm not going to give a full sort of course on the different corporate forms here. If you want to, go for capital gains, and sort of be the classic venture investable vehicle, you're going to be a C corp. And then you're going to be in Delaware. You might also be in Nevada. Some of the West Coast folks will pick that, but really, aside from those two, the only reason to have have your corporation be local in your jurisdiction is if you're doing a sort of lifestyle company and don't ever anticipate raising capital. You do, my first bullet there, want to incorporate promptly because you want to have a place to stash your IP that you're busy creating, and because you want to limit your liability. And you want to observe your corporate formalities so that you limit your liability, because obviously the benefit is you can declare bankruptcy. And one of the things I'm going to say later is, that one of the joys of a startup, although you don't realize it, is that the big risk of a startup is if it fails and goes bankrupt. You know, and it takes all the other risks that you will assume when you create a startup with it when the entity goes bankrupt. So you can start again. So as a lawyer, if I'm working with a company that's got $100 million in the bank, there's a lot of risks I have to try and defang. If I'm working with a startup that's broke and just needs to get the deal signed, then, you know, we can take an awful lot of risk knowing that, you know, if we'll sort of kick the can down the road on those other problems. Right now, we just need to get the revenue through the door. The next sort of real big mistake I see is, I would actually say, I don't know that I see this much, but it is what the M&A and investment circle and we, the lawyers who are their trained dogs, are on the lookout for. One of the primary things we're looking at, and that is IP mistakes, because all these companies are, you know, the IP is the key to the company. Failure to have the right set of IP creates a whole bunch of risk. And, you know, at an M&A level, you know, it will affect, many times they pay someone like me to go through all your files, find the places where you screwed up your IP over the course of your, excuse me, the law firm dog appears to have seen a deer. Someone like me to find all the places you've screwed up your IP so that then they can come back and say, well, we said we were going to pay you $500 million, but we're actually going to pay you $300 million because you got these IP problems. And the people who finance you, knowing that that's a game played at the M&A stage, will, you know, do the same sort of diligence to try and eliminate those threats along the way. The thing I will say, you know, in a short course on IP is realize that people get this view that everything is intellectual property, and that's actually not true. That actually the default is that nothing is intellectual property except for things that have been specifically created by Congress to be intellectual property. And those are copyrights, patents, trade secrets, which is actually a creature of state law, so I misspeak a little bit, trade secrets and trademarks. There's a couple of ancillary ones, but that's the IP. So you're going to be looking at, you know, as I try and figure out what's the intellectual property in my company, it's how does it fit in this, you know, into that scheme. Patents are ideas that you disclose to the public for 20 years of sort of right to exclusivity on the practice of that idea. It's got to be novel and not new and non-obvious, you know, and there are other tests to it that we can discuss, but basically you're the first person who has a brilliant idea, you run to the patent office. The United States has been for almost a decade now, a first to file country. We were not for a long time. We were a first to invent for a long time, but we're a first to file. So you're the first person to go to the patent office and say, this is my idea. They give you a patent on it. And there you go. And then you spend $1 million if you want to litigate it. You know, if they give you a patent on it after you spend, you know, $50,000 in legal fees, and then you spend, you know, then you spend $1 million to enforce it. But you can also get, you know, a provisional patent or a cheap, not very good, sort of weak patent for $5,000, $10,000, $15,000, $20,000, depending on the caliber of the firm. And often my, you know, sort of early stage people will say to me, well, should we do a patent? And I think that sort of by the time you've gotten past seed to Series A, really everybody should get a patent, or should be talking to a patent attorney, even in a place like computers, you know, technologies or software where it's easy to engineer around it and where the patent won't have broad applicability like in Europe. And my reason for that is twofold. One, as I said in my outline, you're going to a gunfight, you bring a gun. You're going to a patent fight, you bring a patent. When somebody sends you your first cease and desist letter because they have a patent, you know, related to your product, you're going to be in a much better position if you have a patent related to their product, even if both patents are not worth the paper they're written on. The second reason is because I have seen so many quote unquote worthless patents become the centerpiece of both financings and, you know, and buyout fights. Like people are like, well, I don't really want this company. We could recreate the code, but that patent, we want that patent because it's an old patent. That it just, there is a certain emotional attachment that I've seen in investors on the M&A side, even when we all look at each other, and even when the investor's like, well, I know the patent's probably worthless, but that I think it's worthwhile. So that's patents. Copyrights, there it's, a copyright is any expression, creative expression that has been reduced to a tangible medium. Your copyright vests the minute you reduce it to a tangible medium. So my speaking this presentation out loud is not copyrighted, but since it's being recorded, a copyright is being created at this very moment. The big mistakes in copyright, since I'm focusing on mistakes here, are people who pull open source or scrape data or just go out and think, this is all in the public domain. I can just take this and use it. And that's almost nothing is in the public domain. Almost anything that you can go out and find is subject to some terms of use, website link, something. And as I'll say later, the key is just to record where you got it. You can go, I'm not telling you need to reinvent the wheel and that you can't take stuff that's out there in the public, but figure out where you got it, make sure you know what the rights were. There's no reason to rewrite a set of code if there's an open source program that is properly licensed that you can do it with. But when you get to that M&A point, you're going to have some nerd like me who's like, that's open source code. And what was that licensed under? And if it's the wrong license, we're going to be going after your value. So you want to do the housekeeping up front, 5 minutes of housekeeping. I downloaded this. This is the MIT license. Stick it in the file folder. Will save you so many headaches later on. Trade secrets are a creature of state law, but basically, generally nationwide, it is something that is in fact a secret. That's important. If it's public information, it's not a trade secret. It is in fact a secret, that you take reasonable efforts to keep it a secret, and that you derive value from the fact that it is secret. This applies to ideas. And again, the classic here is the formula for Coca-Cola. And the difference between a trade secret and a patent is that patent is 20 years and then it's open to the public. That trade secret, like the formula for Coke, can stay a trade secret and be valuable IP for as long as you can keep it a secret. The place people mess up here, and I actually got a really sort of heartbreaking call on this today, is they skip doing what I call residuals, residuals, but everybody calls it residuals, and what I refer to as a freedom to operate provision. And this is slightly different from freedom to operate in patent sense, but it is the idea that there's an idea that exists in both trade secrets and copyrights that if you've been exposed to somebody else's IP and you create something similar to it, then you are presumed to have stolen it, and the burden of proof shifts to you to prove that you didn't steal it. That's proving the negative, which we all know is near impossible. And because you have the burden of proof, they can at least drag you all the way to an end of a trial. So that's at least $200,000 in legal fees before you have gotten to the point where you can prove that you didn't steal the thing if you win. So when those trade secret cases come up where somebody accuses you, of stealing their trade secret, again, they have disproportionate leverage. If you had access to it and your thing that you produced is similar to it, they have disproportionate leverage to say that, to come and collect from you, even if you're like, well, this is public, this is obvious, I don't understand. It can be very painful. And so as an example, and again, some of this will come up down later, but the call today was somebody who had found a partner who they thought were perfect. And for a year, they worked with another corporation on a potential joint development, really exciting new area. They trained the partner all about their area of the, of business where they were the expert. The partner trained them about the use of the technology. And then it broke apart really because the partner got a better offer to work in another area. Now our guys want to go and develop this technology, but we've basically had a year conversation with somebody else who trained us all about technology and who said, don't you think you can go take all this and create your own widget? What a residuals clause does is a residuals clause says, what I retain in my unaided memory, I can use any way I want. You can't stop me from using my learnings. And so I can shift that, solve that burden of proof problem by saying, okay, I took all the tangible embodiments, I took all the papers, all the files, and I threw them out. And now I can go create whatever I want because I'm just recreating it from my unaided memory. The freedom to operate provision states, when you see them, they'll be something like, we acknowledge that both of us are developing in this area and may have products that are similar to one another's, and nothing in this agreement will prevent us from continuing to innovate in the area. So those two provisions in an NDA can cut both ways. If you're giving somebody your secret mojo, it helps them, sort of cover their ass to steal it and run with it. But if you're being exposed to their secret mojo, it covers you. So you really want to think about those things, because when those relationships go bad, that is, those clauses are very important. And that is, I focus on, like, I see that, like, I got a call on that today. That is a thing that comes back. So I'm not going to talk about the rest of it. You should definitely have an IP strategy. It is a good idea to sit down with somebody and say, okay, this is what we want to do. How can we use IP to protect it? I put in here data as IP now, because we have been undergoing and are continue to undergo, I should almost add AI in here. Like, data is the new oil was the title of a presentation I did 15 years ago. And it really is now. And every single startup I work with is finding ways to monetize their data. And so you really probably want to be thinking, and my last bullet is about data privacy and data security. You want to be thinking about what's in my data and how can I monetize that, or how can I at least sequester the data so that I can monetize that value? Because what we're seeing now, or what I'm seeing, is with the emergence of AI, these big pools of data that, like, there was a point at which after the sort of 2008 Healthcare Act, there were all these huge pools of medical data, but nobody knew what to do with them. They had them, they'd all been created, but nobody could do anything with them. Well, now they've got the AI spiders that can crawl through them and do amazing things. And so you do want, and data is not clearly IP. That's its own legal discussion, which I won't bore you with here. But you do want to think about, do I have data that's valuable? And if so, how can I protect it? The accelerators, partnerships, and joint development, oh my, lions, tigers, and bears. That's where I see people have problems on the NDA side, especially some of the accelerators, or you'll get a partnership where somebody's like, yeah, come on in here, big 800-pound gorilla says, yeah, come on in here and let me see your stuff. And, and if we like it, we'll buy it. And if we don't like it, we'll throw you out and then we'll just make it ourselves. You got to be really careful. Those should be sort of little red flags to not do them. I was involved early on. I wasn't involved with the initial deal, but early on with Citrix's embedding some of the Citrix core code in the Microsoft kernel. And as you might imagine, I have read the deal. The deal between Microsoft and Citrix was just like, Citrix was just lying on the rock, letting Prometheus eat its liver. Not Prometheus. It's late at night. Lying on the rock, like Prometheus, letting the vulture eat its liver. Anyway. It was a really bad deal, but because their technology turned out to be so vital for Microsoft and was in the middle of Microsoft's technology, Citrix became the company it did. It grew very rapidly. It became a powerhouse. So there are times when, yeah, you want to just throw up your hands and be like, okay, I'm gonna, trust God and Bill Gates, God help me, and risk being taken advantage of. But there are lots of other times it doesn't work so well. So I'm going to not go into the same detail on these, though I will happily come back in questions. You want to be frugal with your equity and careful with its issuance. Those are two different things. The first thing that I think most investors will have beaten this into any sort of startup group, but is that equity runs out really fast. People, when they start up, are like, I got all this equity. What do I care if you get 10% or 12% or 15%? It's like, no, you were not going to have enough equity. If you do that, once you start selling 50% and once things start getting watered down. So you really want to be frugal with it. You want to make sure it is all subject to vesting. You want to watch out about, to giving it away to friends and family or selling it to somebody who's not an accredited investor. There are mistakes you can make here. This is on the careful with its issuance side, where, you can sell it to someone who's not accredited. You can do a transfer of equity, or even a convertible note, which is a document that under blue sky laws, state security laws, needs to be disclosed and registered with the state. And if you don't follow the niceties there and the company goes south, you can be forced to basically refund the money you took in that equity purchase, as well as fines and things. So messing up securities sales is dangerous. You also have these fun tax code things, the 83B elections. If you are issuing options or restricted stock and you don't know what an 83B election is and you are working with a lawyer, kick your lawyer in the shins. That is a 101, your first year associate, make sure you do your 83B elections. 409A valuations, if you are issuing options, the board of directors of the company needs to make a determination as to the value of the company when you issue the options. That means that nobody gets options until the board issues the options. And another frequent mistake, it's easy to say to somebody, I'm going to give you 5% of my company to come join it. Here's 5%. But then you never have the board vote, you never do the valuation, you got a problem. Pick the right name. Obviously, you want to clear it for trademarks. This is a sort of list of the things you want to think about and can do. Keep it simple in your contracts. This has really was my bread and butter for the first 15 years of my career. I think it's important for a startup to think as much about how you're going to form the contract as you do about the words in the contract. I like to make my contracts look like 6-point type, 2 columns, like we've signed 10,000 of these, everybody signs them. If I could get it on pink paper in gray text, I would. If I can't do that, then I always think it's worth the money I'm happy if you want to pay me to negotiate 1 million contracts, but otherwise spend $10,000 and get like a click-through engine so that you can just put the contract up on the screen and somebody will click through it without negotiating it. Those are, what I'm trying to deliver to my clients when I draft and negotiate contracts for them are things that will mitigate your risk as much as we can without slowing down your path to revenue, right? And the 2 things that a contract have to get right, I say pick your fights. We got to get the IP ownership right. If we screw that up, that's the end of the company. And we want to get the limitation of liability right so that, if a contract goes bad, hopefully no single contract is the end of your company. Beyond that, I want to push back on the risk that I can, but for a startup stage, and this is advice for a startup, not for a mature company or somebody who's got a couple million in the bank, like 10, 20 million in the bank. For a startup stage, everything else to me is just deal with it as a practical risk, sort of what can we do, what can we get, but don't burn cycles on legal time and creating the perfect contract, burn cycles on selling more business. I have said, I frequently will say, in my career, maybe I've seen 2 or 3 companies go out of business because of a bad contractual dispute, maybe, where I've seen 100, 200 startups go under because they didn't make their revenue, make their revenue numbers fast enough, or the market turned against them at the wrong time. So keep your contract simple. There are as many styles of contracts as there are human faces, because, obviously, if you're selling rocket launchers to NASA, that's not going to be a simple contract. But you want to keep it as simple as you can for the industry you're in. You want to pick your fights. You want to make sure that you spell out the obligations of your counterparty. Another frequent mistake I see is people who are like, well, they're we're going to give me do a press release or a white paper with us, but it doesn't say that anywhere in the contract. So you do want to at least look through it and say, what is it I'm expecting to get here? And then don't use ever, just as an aside, but when I see when sort of entrepreneurs draft contracts themselves, they'll be like, the fee is $500. That's great. So nobody has to pay that fee. It's just the fee is $500. Nowhere does it say the customer will pay the fee. It just says the fee is $500. And it's kind of implied there, but when you get into a litigation over something like that, that kind of passive voice stuff will kill you. I do want to say, avoid free legal boilerplate. Really seriously, avoid it. I see more mistakes. Find a cheap lawyer, find a bad lawyer, but get a human being who has actually read the law. Give them the cheap legal boilerplate you found that you think is right. Do the legwork for them if you're really penny pinching on the legal side, but get a lawyer involved, because again, it's the nightmare scenario. Someone comes in and they're like, well, I got this privacy policy off LegalZoom and I found this thing on it, on the internet. and the stuff is not at all related to their business and actually has put them into a worse position. And for example, and I point out here that the two biggies are privacy and liability releases, because they have to be specific. And with privacy, sort of the rule in privacy law generally is you can do what you want. This is getting narrowed as we get more legislation, but you can do what you want as long as you disclose it, as long as you explain what you're doing. So then I relatively frequently get people like, oh, this is a privacy policy I got from my competitor's website. And I'm like, so do you also store your data in Kathmandu? And they don't look at it. But the privacy policies are very bespoke. They're very specific to what you do and where the data is stored and what you're taking and who your partners are. So you can't cut and paste them. And liability releases, my favorite is I went to a puzzle room and they had to sign a little contract with a liability release on the front of it. And so I, being a lawyer, flipped it over to read the liability release. And it said that they were not responsible for packing my parachute. So, I thought the puzzle room was going to be a lot more fun than it was. I will tell you that. But, you want to pull those cut and paste, you want to have a liability release that actually fits the places you might have liability, because the courts will narrow those to the actual liability. Mind your employment P's and Q's. The two big ones here. In the United States, everything's employment at will. There should not be an employment agreement unless you are hiring a doctor. Medical practices will have them because of non-compete issues, or like it's a CEO level thing. Otherwise, you get an offer letter, it describes the offer, but it's employment at will. And if an employee asks you for an employment agreement, what they're asking you for is an offer letter combined with a non-compete assignment of inventions and non-disclosure agreement, which is what you sign the same time, that sort of assigns your IP to the company. Excuse me for a second while I yell at Law Dog. Now I can't find my mute, so you guys are all just gonna get to hear Law Dog for a little while longer. Oh, good. Both dogs are starting.
It's okay. Law dogs have got stuff to say. That's good.
We had a conversation. I barked back. All right. So end of this is, we talked about that. Avoid free legal boilerplate. So that's where I see the mistakes. Don't steal boilerplate, but you can and should look at your competitors' contracts, see what they're doing. That's always when I have a young startup and they're trying to save legal money, I'm like, get me your competitor's contract and mark it up to sort of say how your business would run like this. The other reason to talk to a lawyer here is because a lawyer can tell you what is missing. And, so it's one thing if you take a form, but you won't know what's missing from the form. Mind your employment P's and Q's. We talked about offer letters. That's where I was. Sorry. My dogs distracted me. But yeah, so all employment is at will. You can, and then the other thing I would be careful about is using employees versus contractors. Usually you want to start using people as contractors until you've got, sort of the payroll and all the items set up to actually have employees. But you do want to be careful. We're seeing more and more sort of pushback, and I think companies like Uber, where everybody's a contractor, nobody's an employee, have sort of caused California to come out with more aggressive interpretations of like, this is not a contractor, they're an employee, and ergo all these, sort of employment type obligations apply to them. So you definitely want to think about that. The distinction there, by the way, is whether a contractor is given a goal and then chooses how to achieve it. An employee is someone who you're basically micromanaging what they're doing to, on a day-to-day basis. But so you want to realize that that's a risk. Again, you want to everybody gets equity vesting all the time. If you are doing interviews, familiarize yourself with what the prohibited interview questions are. There are just some things about protected classes that you don't want to ask. Number 9, towards the end of the list here, is make document management a priority. Again, when you go to sell the company, you can have lots of stuff that you don't have hands on, but you want your board resolutions and minutes. You want your signed contracts. In particular, in here, what you really want is any place, I go back now to where I told you, if you're scraping copyrights, any place you got IP, anybody who touched your IP development process, I want an assignment of inventions agreement that should be in all capital letters here. That is critical part of it. That is one of the things that will kill an M&A deal, is if they're like, well, Jenny was involved in developing this, but she left, she moved to Greece, and we lost her. We know she signed one, but we don't have it. That will stop an M&A agreement cold. Just boom. If we don't have one of the major contributors assignment and we can't get in touch with them, we're not buying your company. The other documents here are sort of common sense, but put them all in one place. Take an extra 2 minutes to, when the final signed document comes in, to put it in the right folder, and you will be so much happier when you're trying to negotiate some big M&A deal or big fundraising, and you aren't spending time looking, behind your file cabinet for things. And then lastly, and I say this is in this sort of current environment, because I am seeing it across the board in startups that aren't even related to data and PII, and because of the increased legislation and risk on privacy nationwide in the US and indeed overseas. I think I talk to every startup now and say, you really want to, even if it turns out you have zero data that's valuable and the only PII you possess is the names and addresses of your 5 employees, you want to do a conscious evaluation of those 2 things, because the first, the data that you may have is hidden gold, and the PII is another thing that can kill a financing or an M&A deal if it's not handled right. But if you put the policies and procedures in place to handle it correctly early on, it turns from a tiger into a kitten. It's very easy to handle. So I just dumped a whole lot of information on you in a short time while still screaming at my dogs. I am happy to take any questions or to revisit and unpack any point with possibly maybe more coherence than when I first touched on it. You let me know.
David, thank you for coming and joining us. Tom, I know you just raised your hand, but I'm gonna go first, if that's okay. And one of the common questions that we talk about from a startup's perspective: how much should we budget for someone like you to help us set it up right?
It's funny because I said, Susan asked me that question in regard to her startup. I'm revealing.
Did she? Oh, good. Okay.
Client secrets, and I was like, well, when I was at my big firms, I know it was the first thing that every lawyer looked at when they got a business plan was, what's the legal budget here? But the answer is really, if you're, and it depends on whether you need a big firm or you can find a competent small firm, right? It is, I would, on the one hand, a lot of the big firms will give you sort of there are a number of freebie programs out there where they use it to train their associates, and it's very cookie cutter. And so it'll be sort of 20 to 50K to do all of this stuff, but you're going to get a very junior associate doing it, but that may be fine. I mean, and so I guess my first answer is, I think 20 to 50K, to sort of get fully set up with all of the junk I'm talking about here. Yep. But then it might be that, oh, actually you have a real serious data security issue that we need to dig into, or, again, I had an LLC for a little while and now I've got to unwind that. There are items like that that will, that I'll look at and be like, yeah, that's too low. In general, for the sort of I've been out of a big firm now that, my rates, I set up BTL because I liked working with startups, and my rates were near $1,000 an hour. So I was able to cut them in half by setting up my own firm. And oddly, sort of part of the story is, and have got incredibly busy because all my friends who are at big firms send me their companies to take care of day-to-day. Because we don't do big M&A work here. We won't sell your company, and we'll do your basic formation work. but we won't, I'll do your series seed round. I might get up to a small series A, but after that, I'll refer you to a bigger firm with tax counsel to do sort of bigger fundraising rounds. That's not what.
Yeah, I guess my budget was really at the start. By the way, a quick favor, could you mind stop sharing so we could see everyone in the gallery view?
Yeah, absolutely.
But
yeah,
and that really helps. Now, I will say that many of us are in the 20,000. Well, that's that blows my entire budget away. Like, I don't have that kind of money, which leads me to my second question. Do you have any opinions on Clerky or Gust? Are you familiar with those more boilerplate platforms?
I'm not familiar with those guys.
Okay. With my startup, we used Clerky. I don't recommend them. Just saying we use them. Gust is a competitor. They have a pseudo boilerplate. A click through, you can fill in a couple things, and it makes some contractual make some contracts for you. It files in Delaware for you. You pay their fees. You're done. Again,
I've run with those. That's sort of where I've run into a number. And it may be the people who did that perfectly and it all worked. They never come to me and are like, "Oh God, help us unwind this," right? So I never see those, but I've seen the nightmare scenarios. And it just finished what I was saying before. It just is. I think you go to a big firm and you get the freebie package and you get set up, and a young associate sort of cuts their teeth and learns how to set you up. I actually think that's a reasonably good deal. I don't object to that. Or if you can find a small firm that's got the bandwidth to put you on, but that's how most of the people I know do it. And then they sort of get to the point where you've gotten to the end of the free services, and then you need to decide if you want to spend $1,000 an hour or not.
Right. Yeah. And free services. Wait. Yeah, we want that. Just up until we have to start paying for it. And those are the things that we as entrepreneurs are always facing. It's like, where do we spend our money? And when do we spend our money? Those are the big fears. I guess my last question, I'm going to go to Tom. What do you suggest we do if and when it all starts to go south?
Take a deep breath.
Mm-hmm.
Don't burn evidence.
I didn't even think about that. That's a good idea. No, sorry.
Yeah, no, that is some people's first impulse.
Wait, no.
A startup is a roller coaster ride. You didn't get into a startup because you didn't want to ride a roller coaster. And so like anything else, it's take a deep breath, get a competent lawyer, find somebody who's actually one of the other sort of things that other people might say is find somebody who's an expert in the area you're working in. Don't go to Uncle Bob. Uncle Bob might be the world's greatest med malpractice lawyer, but don't go to him when you've got a serious privacy problem. It's find someone who's an expert. And then the answer, one of the things that I love about my job is, people come to me with these things that they think are these unsolvable IP problems. And I'm like, I've done that 10 times. And I feel like really special, but it's because I've lived in this specialty area where this shows up. And so these problems that seem unsolvable, there's there's a playbook. There are people out there who've done it. And so it's just taking a deep breath and finding a lawyer and then working through it. But it's also preserving the evidence and being calm and rational.
Wonderful. David, thank you. Tom, we'll go to you. And if anybody has any questions, please raise your hands. Tom.
Yeah, Todd, actually, you asked my question for me. I was going to ask David, and thank you very much for the very insightful talk. I was going to ask you if you had ever seen any cases from your clients where either Clerky or Stripe Atlas or the other ones Todd was mentioning had done something that was really wrong. I get the free online Google things are wrong, but I don't know. I pay like $700 for the Clerky thing. It's worked really well for me so far. I do now have counsel, and it's seems like everything's fine. Maybe I'm wrong, but seemed like a good idea to me at the time. Just curious.
I guess it is where I've seen the mistakes. It's because I'm not familiar. I'm sort of familiar with Rocket Law and Zoom Law and those, and so I haven't looked at Clerky, and maybe they've gotten better. Maybe they've got an AI level in there now. But what was happening before is we'd see people who, again, made some of the other mistakes I'm talking about here, just picked the wrong entity, or didn't have someone to remind them to file an 83B election because it was automated, or, just made dumb mistakes, or, took a set of boilerplate, that in terms of how they handled their annual meetings, that, like, as an example now, I haven't seen this, but as an example now, there's a new provision post-COVID that you can have board meetings by Zoom, in the Delaware statutes, but you got to put it in your bylaws that that's permitted in order for it to work. And so you'd see something like someone forgot to put that in their bylaws, right? So they're little.
But how bad would that be if you started a company and you forgot to put it's okay to put Zoom board meetings, and you did, but what's the damage there? Can you fix that, or is it like the company goes over?
So to give you an example, and we are talking about a hypothetical here, because I haven't, I'm actually don't remember the specific wording of that Delaware statute, but as an example, it would be like, so then we have a board meeting, it wasn't authorized. In that board meeting, we vote to do a deal, right? And we okay the deal, and then the valuation of the company goes south and we lose a bunch of money. And now the investors come back and say that was never authorized because the board meeting wasn't authorized.
Oh, so this is like it's like a catch, like, oh, because you didn't follow this rule, and you didn't have it outlined in your bylaws at the beginning, you're violating your bylaws.
Yeah, I mean, what happens with all legal issues, right? You can make, and people do make, a ton of legal mistakes every day. You're going to have to run a startup. You're going to make lots of legal concessions every minute, or you are going to be bankrupt and out of time from the start, right? These things only become an issue when you make a lot of money, or two people with a lot of money are getting angry at each other and your startup's in the middle, like, two investors or whatever. So, and that's the point where they, again, hire some big law firm to come through and comb the details and find those stupid little mistakes.
Got it.
So
we as entrepreneurs have to balance the legal risk with the business risk and the expense.
Yep.
Okay.
Yeah, that's exactly right.
I was just looking through my bylaws here, and it says that the meeting of stockholders shall be at any place within or outside the state of Delaware designated by the board of directors. So if I had an investor who was going to try to screw me over because the place was online, I would be really worried about that investor.
Yeah, I agree. And again, but you wouldn't know about that. And indeed, the investor probably wouldn't do it. I suspect that language is probably sufficient, but I don't remember offhand if the statute says it has to say electronic. But you wouldn't know, the investor wouldn't even know it was their option until they had decided they wanted to sue you because they lost all their money and you were now being bought for a penny a share. And, and they sent their lawyers to go look through your bylaws and find reasons to cause trouble for you.
Got it. Tom, was that all your questions? Oh, good. Thumbs up. Susan, please, folks, raise your hands.
Yeah, I have probably a comment more than a question. So yes, David is doing Satya's and my company's legal stuff. And I would say I've had a couple of big lessons learned. The first one is that all lawyers are not created equal. I started with a kind of generalist lawyer, LLC, who was very good about saying, I don't know about startups. I don't know about equity stuff. I'm just your general lawyer. And I, in my infinite naivete and stupidity, said, what could go wrong with that? And so what I've learned is it's super important to find a lawyer who is who is an expert and who has a lot of experience in what you're doing. So for us, we're a SaaS company, product led, all of that stuff. And then I think my second takeaway is also having worked with lawyers from really big companies, and the classic kind of I don't know, caricature of lawyers of like, you get 3 of them on a phone call and they're all charging you, the paralegals charging you, the lawyers charging you, the senior lawyers charging you, the, person making coffee is charging you. What I found with David's company, so I'm endorsing them, is that they only charge me for one person. And oftentimes there's more than one person because there's different pieces of expertise that I'm needing to tap into to do something. And then my third piece about it is, my third lesson learned was, with that expertise, things can go really fast. I mean, we did a C corporation. We did all this stuff super fast, like in a week and a half, trademark, C Corp, a whole bunch of other stuff. So there's something about just that extreme expertise and experience that makes it go really, really quickly after I had been working on this stuff for a very long time beforehand. So just wanted to pass that on to everybody. Some lessons
There's an
learned from our
endorsement,
point.
which is like, so with that endorsement, it's like, David, can I call you tomorrow?
I'm always here, although I've got to get Susan's legal work done. So,
Oh, okay.
but yeah.
So I'm gonna cold call Jen, because as soon as I'm like, we're about to wrap up, she's gonna raise her hand at the very end, and now she's scratching her head. Jen, do you have any questions for David?
I have a very simple one. All right. So for startup, before you're getting like a solo, like solo owner, before you're thinking about to get a team, not the co-founder or something, and what kind of criteria legally I should consider?
Are you talking about for just the creation of the corporation?
Startup. Yeah.
Yeah, I mean, so you have the most flexibility then. That's always, when I get that case, there always is this sort of, do you want to do a Delaware C Corp and just jump straight to it? Or, do you want to have that, since you're going to have much more control, do you want to have some sort of interim body? I mean, even in that case, I would say you might create a Delaware corporation, but make an S Corp election so that, the tax losses are, I saw the jokes in this chat afterwards about tax losses, but yeah, well, these really rich people need tax losses.
Yeah.
But, you make the S Corp election so that the losses flow through to your personal income taxes. So you can do that. And that is probably what I would advise, but it does get into that, if it's a lifestyle company, and that might mean you're working your tail off, then an LLC is just going to offer you a lot more flexibility. Corporations are creatures of statute. They all look alike. That's one of the reasons the venture capitalists like them. They're just cookie cutter in many ways.
Mm-hmm.
But so that, I would definitely do that as opposed to some sort of partnership, because I want the limited liability, and I think that you're going to be more bulletproof with an LLC or a C Corp. And I think that as between doing it locally, the only downside is of doing Delaware as opposed to, say, if I'm in Mass, so I'm doing a Massachusetts corporation, is I'm going to end up having to pay, somebody for a Delaware office for a Delaware mail drop. But if I'm ever thinking about doing the financing down the road, then I'm just going to start in Delaware. If I'm never going to do financing, then I might start in Mass.
Okay. Wow, that's very helpful. Thank you. I'm thinking move to Boston. How are you?
It's a great town. I love it.
Right.
Jen, thank you. So David, I just want to, if there's any other questions, I guess, Susan, should we?
It's free legal advice hour too. I'm not your lawyer.
I don't have a question, but I have a similar endorsement like what Susan was mentioning. So one of the points that David mentioned was keep it simple, right? I've never seen a lawyer do that in practice, right? I've noticed David do that in practice, keeping it simple. I've worked with a lot of corporate lawyers over 20 years. They always complicate, but this is the first time a lawyer advised us to keep things simple. So in practice.
I love it.
Well,
So
I-
what? Oh, sorry. Go ahead.
I was just to say a lawyer's version of simple. My wife would be like, that man does not know how to keep anything simple. Compared to a lawyer, I keep things simple, but it's still, anyway.
So what I want to do is because I
And
know
Victor's hand is raised too.
I see it. Hold on. I
Okay,
see
all right,
Victor's hand.
cool.
Before I get to Victor, what I would like to do is let's we'll end the recording just because I think there might be a few questions that people might want to ask off the record. So if that's okay, if you could stick around for a few minutes after we end the recording. But before we do that, Victor, did you have a question?
Yes, I was going to ask if Andy could introduce his +1.
Oh, yes.
Uh,
We're calling Andy, Victor.
On the record. Say hi, David.
Ooh, beautiful,
Hello.
beautiful, beautiful.
You
Wow.
see a fishy? There's a fishy. There's a fishy over there.
Is she the HBAP baby?
yes.
This is our Ethan baby. He's just about to start walking.
Wow.
Can you believe that?
I
Unbelievable.
know, it's so quick.
All right, so I'm going to finish this. David, thank you for coming and
Yeah, thank you.
doing this. This is incredibly valuable information. Please, folks, stick around. Don't forget that we've got a lot of upcoming things in the next several weeks. Thank you again.
Thank you all for the opportunity. Appreciate it.
Very